Claude responded. Eleanor Voss had been reviewing the morning's estate intake files for exactly 47 minutes when the receptionist knocked on the glass panel of her office. Eleanor Voss had been reviewing the morning's estate intake files for exactly 47 minutes when the receptionist knocked on the glass panel of her office door at Hartwell, Bryce and Calder on a Tuesday in March. She was 3 files deep into a particularly tangled probate matter, a contested will out of Westchester involving 4 siblings and a lakefront property worth somewhere north of $2 million, and she had her reading glasses pushed to the end of her nose in the way that meant she was concentrating hard enough that the rest of the world had gone temporarily muffled. Ms. Voss, the receptionist, Priya, said carefully, "Your 11 o'clock is here." Eleanor looked up. Standing in the waiting room on the other side of the glass, turning a leather handbag over and over in her hands the way people do when they are nervous and trying not to show it, was a woman Eleanor recognized before the woman had any reason to look her way. Her Aunt Marlene. Marlene Gruber, née Marlene Calloway, now bearing the last name of her second husband, was 61 years old and wearing a camel-colored coat that Eleanor remembered from at least 4 Thanksgiving dinners. She was looking at a framed print on the waiting room wall with the focused expression of someone who is not looking at the print at all, but is instead rehearsing something she planned to say. Eleanor set the file down. She had prepared for this moment in a general way for a long time. She had not prepared for it to be a Tuesday in March. "Send her in, please," Eleanor said, and she folded her hands on the desk and waited. "Hello, everyone. Before I continue, if you've ever been told you would never amount to anything by someone who should have believed in you, leave a comment below. I want to hear your story. Truly. Because what I'm about to tell you took me 18 years to live and about 30 seconds to understand completely. And some of you are going to recognize pieces of this story from inside your own families. To understand why that moment mattered, why Marlene walking into my office felt like a door I had been holding shut for 2 decades, finally swinging open on its own hinges, I have to take you back. 18 years back. To a birthday party I was not supposed to enjoy, at a house I did not feel welcome in, on a day that changed the direction of everything. I was 21 years old in the summer my grandmother turned 72. Grandma Ruth Calloway, legally Ruth Adeline Calloway, born 1952 in a small town in western Pennsylvania, had been the center of the family's universe for as long as I could remember. She was the kind of woman who kept meticulous records of everything. Birthday cards sorted by year in a shoebox under the bed, receipts for appliances she had owned since 1979, a handwritten ledger in the kitchen drawer that tracked every dollar she had ever lent to any member of the family, with dates, amounts, and this is important, whether or not it had been repaid. I adored her. My mother, Donna Voss, was Ruth's youngest daughter. My Aunt Marlene was the oldest. And between those 2 women, the question of who mattered more in Ruth's eyes had been a competition so old and so entrenched that I had grown up inside it without fully understanding its shape until that summer. The birthday party was held at Marlene's house, a 4-bedroom colonial in Chestnut Ridge, New York, that Marlene spoke about the way other people speak about landmarks. The guest list was maybe 30 people. Extended family. A few of Ruth's friends from her church group. My cousins Becca and Derek, Marlene's kids, who were 19 and 23 at the time, and had always occupied a different tier of family consideration than I had. I was the scholarship kid. I had gotten into Fordham University on a combination of academic merit and financial aid, and I was working 22 hours a week at a campus library reference desk to cover the gap between my aid package and my actual costs. I did not have money. This was not a secret. My mother did not have much either, and what she had, she kept carefully. The gift-opening portion of the party was held in Marlene's living room after lunch, and I had brought Grandma Ruth a card and a copy of a book she had mentioned once, 2 years prior, during a long phone call we'd had about a documentary she'd watched. It had cost me $14.99, and I had wrapped it in the tissue paper from a shopping bag because I did not have wrapping paper. I was not embarrassed about this. Ruth had raised women who understood the difference between the thought and the packaging, but Marlene had not raised her children that way. Becca and Derek gave Ruth a jewelry set, pearl earrings, and a matching bracelet in a velvet box that Marlene had probably purchased and put their names on, but which gleamed impressively under the living room lighting. Several adults made audible sounds of appreciation. My mother and I gave her our envelopes and our book, and Ruth held them warmly and thanked us with the exact same quality of attention she gave everyone. That was Ruth. She was genuinely fair. What happened after was not fair. After the formal gift opening, Marlene pulled my mother aside into the kitchen. I was not supposed to hear. I was standing near the doorway getting a glass of water, and I went very still. "You know Ruth is going to need help soon," Marlene said. Her voice was the controlled, even voice of someone who has decided something already and is announcing it rather than discussing it. Real help, financial help, and I just want to be clear that I've been the one managing things, and I'll continue to manage things, and I don't think it's realistic for someone in Donna's situation to be involved in those decisions. My mother said something quiet that I couldn't catch. "Eleanor is sweet," Marlene said, "and I heard my name the way you hear your name when you are not supposed to hear it, with a strange doubling effect like hearing a recording of your own voice. But she's not going anywhere. You know that. She's working at a library. She's going to end up in some clerical position somewhere, and that's fine, but she's not the person you call when there are serious matters on the table." I stood very still with my glass of water. "She doesn't have the temperament for serious things," Marlene continued. "She's too quiet, she thinks too much, that's not a skill set, that's a personality quirk." I walked back into the living room. I did not say anything to my mother about what I had heard, not that day. What I did that evening, driving back to the apartment I shared with two other students in the Bronx, was think about the word temperament, about what it meant that Marlene had used it as a dismissal, about whether she was right that my quietness was a deficit. She had also said something else at the party, something she said at the table in front of the whole group, when someone asked about a family friend's legal trouble with a probate matter. "Estates are complicated. You need someone serious to handle those things. Someone with standing. Not everyone is built for that kind of responsibility." She had not been looking at me when she said it. She had not needed to. I had written down the name of a program that night on a small piece of paper, the Joint JD program at Fordham School of Law, with a concentration in trusts and estates. I folded the paper and put it in my wallet. I kept it there for 6 years. The first real obstacle arrived earlier than I expected. In my senior year of undergrad, I applied to Fordham School of Law through the early application cycle. My undergraduate GPA was a 3.71. My LSAT was 164. These were not spectacular numbers. They were solid, workmanlike numbers that reflected the reality of a student who had been working 20-plus hours a week for 3 years and studying in the hours that remained. I was waitlisted. Not rejected. Waitlisted. Which is its own particular form of suspended uncertainty. You are not told you are not good enough. You are told to wait and see whether you might be good enough if enough other people decline. I received the letter in February. I did not tell my mother. I especially did not tell Marlene. What I did was contact the admissions office and ask, specifically, what a waitlisted applicant could do to strengthen their position. The admissions coordinator, a woman named Sandra Osai, was the first person outside my immediate life who said something that actually helped me. She told me carefully, because admissions coordinators are not supposed to coach applicants, that additional letters of recommendation from legal professionals, particularly those with ties to trusts and estates practice, would differentiate a waitlisted file. I did not know any legal professionals, but I knew how to find them. My undergraduate academic advisor, Professor Gerald Kaufman, who taught estate law as a single elective in the economics department at Fordham, had spent 15 years as a practicing attorney before he moved into academia. He had supervised my junior year research paper on intestate succession laws across 3 states, and he had written in the margin of my final draft, in red pen, "You think like someone who has been wronged by a bad system. That's actually useful in this field." I went to his office in March and asked if he would write me an additional letter. He looked at me over his glasses. "You're the waitlist?" he said. "Yes. That's a mistake on their part," he said. "Sit down, I'll need 20 minutes. By June, I had been moved off the waitlist and offered admission for the following fall. The financial aid package covered $31,500 of my first year's costs. The remaining $14,200 I covered through a combination of a part-time position at a downtown legal services organization and a private loan with a 7% interest rate that I spent the following 4 years paying back. My mother cried when I told her. She called Marlene to share the news. Marlene said, "Law school, that's a long road, and the job market is brutal. I hope she knows what she's getting into." I was in my mother's kitchen when Marlene said this on the phone, and my mother looked at me with a complicated expression. the expression of someone who loves two people who are in conflict and does not want to choose. I smiled at her. I squeezed her hand. And I went back to my apartment and read the course catalog for every class in the trusts and estates concentration until midnight. The family had made their position clear. I had no intention of auditing it. I had every intention of building something they would one day walk into without recognizing. I started the JD program at Fordham School of Law in the fall, and I want to be honest about what those 3 years were like. They were not cinematic. They were not a montage of triumphant late nights and turning points set to swelling music. They were dense and exhausting, and occasionally humiliating in the specific way that law school is humiliating, which is to say, you are regularly asked to perform competence in front of peers who are also performing competence, and some days the performance holds, and some days it does not. But trusts and estates was different for me. My property law professor, Dr. Anita Ferreira, who had clerked for a federal circuit judge before joining the faculty, and who was known for calling on students without warning and expecting precision, told me at the end of my first semester that I had a natural affinity for complex asset structures. She did not say it as a compliment exactly, more as an observation, the way a physician might note that a patient's reflexes were unusually strong. She said it in the hallway after I had answered a hypothetical about a contested codicil modification that 3 other students had fumbled. She said it while walking away. I wrote it down when I got home. I filed it next to the paper about the joint JD program that was still in my wallet, worn soft at the folds. In my second year, I took on a supervised internship at a firm called Delaney & Stern, a mid-sized practice in Lower Manhattan that handled estate administration primarily for high-net-worth families. My supervising attorney was a man named Howard Brennan, 44 years old, 20 years of practice, who had the precise and measured manner of someone who had learned early that the most expensive problems in estate law are caused by sentences that people thought they understood at the time they signed them. Howard was not warm in the way that some mentors are warm. He was useful. He assigned me real work on real files, and when I made errors, he corrected them with the same flat efficiency he applied to everything. He also, without ever saying so explicitly, treated my questions as legitimate, which was more than most people had done. It was Howard who introduced me, in passing, to a concept I would later build my entire practice around: the coordination gap. The space between what a client's estate attorney has documented, what their financial advisor has structured, and what their medical or insurance records actually reflect at the time of administration. That gap, Howard explained, was where estates fell apart, where a health insurance policy was listed as an asset but had lapsed, where medical expenses had been paid from accounts that affected the estate's taxable value, where specialist appointment records, logged in a deceased person's medical file, became the crux of a contested capacity claim. Most attorneys don't want to go into that gap, Howard told me once, reviewing a file that involved exactly this kind of coordination failure. It's messy, it requires knowing more than one field, most people optimize for one lane. I like messy, I said. He looked at me briefly. I know, he said, that's why I gave you this file. I graduated from Fordham Law in May with a concentration in trusts and estates, and a note in my academic file from Dr. Ferreira recommending me for the Surrogates Court Externship Program, a competitive placement that involved 18 months of supervised practice in New York's probate court system under the direct oversight of sitting judges. 42 applicants, 8 placements. I was the second name on the list. I did not tell my family. Not because I was protecting a secret strategically, not yet, but because the moment felt too careful to share with people who had told me in various ways that careful moments were not mine to have. My grandmother called me on my graduation day because my mother had told her the date. Ruth said, "Eleanor, tell me what you learned." Not congratulations, not proud of you, tell me what you learned. That was Ruth. I talked for 20 minutes. She listened to the whole thing. You sound like yourself, she said at the end. That's good, keep doing that. I had no idea, at the time, that this was the last extended conversation we would have before her health began to change in the ways that would eventually lead me back to everything I had been building away from. The externship placed me at the Surrogates Court in Manhattan, where I spent 18 months working on contested will proceedings, trust accountings, and estate inventory disputes under Judge Patricia Acaffer, a woman of such intellectual precision that I sometimes felt, in her courtroom, like I was watching someone operate a tool I had only read about in diagrams. Judge Acaffer ran a tight program. We were expected to draft briefs that would hold under her scrutiny, which meant drafting briefs that would hold under nearly any scrutiny. I drafted 14 contestable briefs during my placement. 12 were adopted with minimal revision. It was during the externship, in the second winter of my 3-year postgraduate period, that I filed the paperwork to sit for the New York bar examination. I passed on the first attempt. Score, 274. Passing threshold, 266. I called my mother, she cried again. Marlene was apparently at the house when I called, and my mother must have told her because a text message arrived that evening that said, "Congratulations, that's quite an accomplishment." It was the first time Marlene had ever acknowledged that I had accomplished something. I saved the text, not out of sentiment, out of documentation. I joined Hartwell, Bryce, and Calder as an associate attorney in the Trusts and Estates Department in September, 7 years after I had written down the name of a law program on a piece of paper and folded it into my wallet. The firm had 31 attorneys across 4 practice areas. The Trusts and Estates Department had 6, including the 2 founding partners whose names appeared on the letterhead. My starting salary was $87,000. My loan balance at that time was $41,300. I paid it off in 4 years and 3 months. My first major file as a full associate, not as a supervised clerk, not as an extern, but as an attorney of record, was a contested estate involving a trust document that had been amended 3 times in the final year of the testator's life, 2 of which amendments had been signed under circumstances that the family's elder attorney, a man named Robert Fish of the firm Fish and Alton, characterized as reflecting the testator's clear and unimpaired capacity. Our client, the secondary beneficiary, held medical records indicating a diagnosis of early vascular dementia documented in a specialist appointment 8 months before the Third Amendment was signed. The coordination gap, right there in the file, exactly as Howard had described it to me years earlier. I spent 11 weeks building the case. I cross-referenced the medical records against the trust amendment dates. I retained a neurologist as an expert witness. I subpoenaed the insurance policy documents that covered the testator's memory care evaluation. I found, in the health insurance coverage claims from that period, a gap of 4 months during which the testator had received no covered specialist care despite having an active neurologist on record, which was consistent with a family that had been managing information flow around the diagnosis. The case settled in mediation for $318,000 in favor of our client. Howard Brennan, who was by then a senior partner at Delaney and Stern, and with whom I had stayed in collegial contact, sent me a brief email when the settlement was announced in the professional bulletin. It said, "The gap found you." I laughed for the first time in weeks. The settlement was featured in a brief write-up in the New York Estate Law Review, a professional publication, not a general audience one, under the headline Capacity Challenges in Late-Stage Trust Amendments, a coordination case study. My name appeared as the attorney of record. The case citation was assigned. The write-up was 4 paragraphs. I printed it and put it in a folder in my desk drawer, not because I wanted to show it to anyone. Because I needed to be able to look at it on the days when the work felt too heavy, on the days when I sat across from a client who was devastated by what their family had done, and I needed to remember that I had once been that kind of devastated too, and that the devastation had been load-bearing, that it had carried me somewhere. My colleague at Hartwell, Bryce, and Calder, a senior associate named Marcus Webb, who had been at the firm for 4 years when I joined and who would eventually become a partner 2 years ahead of me, was the one person at work who knew anything about my background. Not the full story, but the shape of it. We had been out to dinner one evening after a particularly long day on a multi-party estate dispute, and somewhere between the second drink and the check, I had told him that my family had dismissed me in a specific way for a specific reason, and that I had built my career in direct response to that dismissal. He had looked at me for a moment. "Does your family know what you do?" he asked. "They know I'm an attorney," I said. "Do they know what kind?" "No," I said. He nodded slowly. "Are you going to tell them?" "When it's relevant," I said. He understood that answer. Marcus was one of those people who understand answers that most people would ask follow-up questions about. That was why we got along. By the time I was promoted to senior associate in the estates department, with a dedicated caseload of 14 active files and my name on the firm's website under attorneys, I had been working in trusts and estates law for 8 years. I was 34 years old. I had handled 72 estate matters, contested and uncontested. I had been deposed 4 times, had testified as a legal expert twice, and had been quoted in 3 professional publications on the subject of contested capacity in trust administration. My family thought I worked at a law firm. Technically, that was true. The evening I was promoted, I sat alone in my apartment and opened the folder in my desk. I took out the New York Estate Law Review write-up. I read it. I folded it back up. Then I took out the original piece of paper, worn almost to translucency at the folds. The ink faded but still legible, and I read the name I had written on it 17 years earlier. I held it for a long time. She had no idea what I had become. None of them did, and I had every intention of keeping it that way. The year I made partner, junior partner, but partner with equity and a nameplate and a seat in the Thursday morning case review, my grandmother turned 90. I was not invited to the party. This is not an exaggeration, and it is not a wound I am still carrying, at least not in the way I once was. It is simply a fact. Ruth Calloway turned 90 years old on a Saturday in October, and the party was held at Marlene's Colonial in Chestnut Ridge, and my mother called me the following Tuesday to describe it. She was careful in the way she was always careful, the way someone is careful when they are trying to give you information without having to take a position on it. Marlene organized everything, my mother said. It was beautiful. She had a caterer. That's nice, I said. Becca and Derek gave Ruth jewelry, pearl earrings and a bracelet. I noticed she said it again. The same gift, 18 years later, recycled in the retelling like a landmark. Here is the thing you didn't have. Here is what the good grandchildren gave. The cash distribution was at the party, my mother said, more quietly. Marlene gave everyone envelopes, Ruth's instruction. Some of the grandchildren got jewelry from the estate collection. You weren't there obviously, so there was an empty box. I said, a pause. I don't know exactly. Marlene handled the distribution. I wrote nothing down. I already knew everything I needed to know. The structure of that family, the way it had always allocated weight and consideration, had not changed in 18 years. What had changed was me. 2 weeks after my mother's call, I received a letter, not an email. A letter on heavy cream paper stock from the offices of Warren J. Holloway of Holloway and Slade, attorneys at law, Suite 400, 1221 Palisade Avenue, Fort Lee, New Jersey. The letter informed me that Ruth Adeline Calloway had executed a new will and testament, dated 6 weeks prior, and that I, Eleanor Voss, of 114 West 83rd Street, New York, New York, had been named sole executor of her estate. I read the letter standing at my kitchen counter. Then I read it again. I set it down and I called Warren Holloway directly because his number was on the letterhead and because I am an estate attorney and that is what estate attorneys do. Mr. Holloway, I said when he answered, I'm Eleanor Voss. I've just received your letter regarding the Calloway estate. I'd like to schedule a time to review the complete trust documents and any accompanying financial disclosure materials. A brief pause. Ms. Voss, he said. Forgive me, are you an attorney? Senior partner, I said, trusts and estates, Hartwell, Bryce and Calder. Another pause, longer. Well, Warren Holloway said, and I could hear in the space of that single word the recalibration happening in real time. I imagine this is going to be a very different kind of administration than your grandmother anticipated. I imagine so, I said. I hung up. I stood at the counter for a moment. My phone buzzed. A message from my mother. Did you get a letter? Marlene just called me. She's very upset. I had come that close to everything surfacing before it was time, but it wasn't time yet. I put the phone face down on the counter and picked up Warren Holloway's letter again. I turned it over. I looked at my grandmother's full name printed in the body of the document, Ruth Adeline Calloway, and I thought about a woman who had kept receipts since 1979, who had a ledger in the kitchen drawer, who had said to me, on my graduation day, tell me what you learned. Keep doing that. She had known exactly what she was doing, and now the question was whether everyone else was ready to find out. Claude responded. The letter from Warren Holloway sat on my kitchen counter for 3 days before Marlene called. The letter from Warren Holloway sat on my kitchen counter for 3 days before Marlene called. Not my mother. Marlene directly, which was unusual enough that I looked at my phone screen for a moment before answering, the way you pause before opening a door when you are not sure what is behind it. Eleanor, Her voice was warm in the practiced way of someone who has decided to be strategic. "I'm so glad I caught you. I know this has all been very sudden. Ruth's decision, the will. It has been a lot to process," I said. This was true. "I wanted to reach out personally," Marlene said, "because I think there's been some confusion. She's been declining, as you probably know, and there are some questions about whether she was fully herself when she made certain decisions. Warren Holloway is a fine attorney, but he's not a specialist in these matters, and I've been speaking to some people who have advised me that the executor designation may need to be revisited." I sat down. "I hear you," I said. "The thing is," Marlene continued, settling into the register she used when she was explaining something to someone she considered slower than herself, "Becca has been managing Ruth's affairs practically speaking for the last 2 years. The appointments, the household, the financial things, and it would really make the most sense, logistically, emotionally, for someone who's been present to be involved in the administrative process. I'm not trying to overstep, I just think we need to be realistic." "Of course," I said, "I appreciate you calling." A small pause. She had expected friction and found none, which seemed to disorient her briefly. "So you understand where I'm coming from," she said. "I understand exactly where you're coming from," I said, and I meant it in a different way than she heard it. "Wonderful. I'll have my attorney reach out to Holloway's office this week, just to get everyone aligned." "That sounds fine," I said. We said goodbye. I sat with the phone in my hand. Marlene had an attorney. Of course she did. The question was what kind and what they knew and what they thought they were walking into. I already knew the answer to all 3 questions. She had just told me, without realizing it, that she believed the executor designation was contestable on capacity grounds, which meant she was planning to challenge the will, which meant she was about to walk into a contested estate, proceeding with an attorney who did not know they were about to face a senior partner from Hartwell, Bryce, and Calder, who had spent 8 years building cases in exactly this jurisdiction on exactly these grounds. There was a document on my desk, the full Callaway estate inventory that Warren Holloway had sent over by courier that morning, that Marlene's attorney had not seen yet. I called Marcus Webb that evening. I signed the first document. There was no going back. Marcus met me for coffee the following morning at a place near the office where we had been meeting for years. He was already there when I arrived, which meant he had read whatever I had texted him carefully enough to arrive early. I put the Holloway envelope on the table. He did not touch it. He looked at me. "Walk me through it," he said. "My grandmother named me sole executor of her estate. She did this 6 weeks ago with Warren Holloway of Holloway and Slade in Fort Lee presiding. Holloway has been her estate attorney for 11 years. My Aunt Marlene is going to challenge the designation on capacity grounds. She told me as much last night." "Capacity when?" "At execution, 6 weeks ago." Ruth was 90 and recently diagnosed with early-stage macular degeneration. No cognitive impairment documented anywhere, but Marlene doesn't know that yet. Marcus picked up his coffee. "What do you have?" "I have the medical records from Ruth's primary care physician, Dr. Sandra Abubakar at Northgate Family Medicine in Fort Lee. I have the specialist appointment notes from Ruth's ophthalmologist, the neurological screening results from 14 months ago that came back clean, the insurance policy documents showing her health insurance coverage was current, and her claims history shows no memory care or cognitive evaluation claims. And I have 11 years of trust documents from Holloway's office showing a consistent pattern of deliberate, informed amendment decisions." He was quiet for a moment. "Eleanor." "Yes." "Does Marlene know what you do for a living?" "She knows I work at a law firm." "Does she know what kind?" "She's about to find out." He set his cup down. "Who's opposing counsel?" "She said her attorney." "I don't have a name yet." "You need to formally appear as executor immediately." "I filed this morning." Holloway submitted the appearance paperwork to surrogate's court at 9 a.m. Marcus looked at me for a long moment. Then he did something I had not seen him do often in the years I had known him. He smiled, not the small professional smile he used in client meetings, but an actual full smile, the kind that arrives before you can manage it. "You've been building this for a while," he said. "A long time," I said. "What do you need from me?" "You know Gerald Farrow at the Capacity Assessment Unit at Bellevue?" "I've worked with him twice." "I need a name. Someone independent who could, theoretically, provide a retrospective competency evaluation if one is requested by the court." Theoretically. Theoretically. He wrote a name on a napkin and slid it across the table. I did not tell him that I had already spoken to that person's office the previous afternoon. The close call came 4 days later, on a Wednesday evening, when my mother called while I was reviewing the financial disclosure statement from Holloway's office, a 43-page document that detailed Ruth's assets with the kind of granularity that made it immediately clear Ruth had been planning this specific administration for longer than 6 weeks. "Marlene says you called Warren Holloway," my mother said. "I did. He's the estate attorney. It's routine for an executor to be in contact." "She said you asked for documents." "I did. Again, routine. Marlene is welcome to request copies of anything that's part of the estate inventory through the proper channel, which is Holloway's office." A pause. "Are you being strategic about this?" I looked at the financial disclosure on my desk. At the line item on page 12 that showed a college fund established in 1998 in my name, contributions made annually through 2004, total balance at time of establishment, $31,400, which was almost exactly the dollar amount of my first year of law school's unmet need, and which I had not known existed until 40 minutes ago. "I'm being an executor," I said. "That's what I was named." My mother accepted this. She said goodnight. We hung up. I sat with the financial disclosure open in front of me for a long time. That was the moment I understood exactly how much they had underestimated me. The college fund entry had a notation beside it in Warren Holloway's handwritten index. "See attached correspondence. Tab F was a letter in Ruth's handwriting, dated 4 years prior, addressed to no one in particular and to everyone who would eventually read it. It said, "I established this fund for Alina in 1998 because I believed she would need it, and because I believed no one else in this family would provide it. The fund was never distributed to her." I am correcting that now. I set the document down. I called Warren Holloway the next morning and asked him to flag Tab F for inclusion in the primary estate accounting. Within the week, I had formally requested, through Holloway's office, a complete financial disclosure of all distributions made at or related to Ruth Calloway's 90th birthday celebration, including the cash envelopes and the jewelry distributions, with documentation of the authorization basis for each. I had requested a copy of Ruth's current insurance policy. I had cross-referenced Ruth's health insurance coverage claims against the documented specialist appointment schedule provided by Dr. Abubakar's office, verifying that Ruth's medical records showed no lapse in cognition-related care and no treatment for any condition that would affect testamentary capacity. Marcus sent me a message that afternoon. "Farrow confirmed he's available through May." I sent back, "Good." The following Friday, my assistant forwarded me a letter from an attorney named Gregory Shawn of the firm Shawn and Petrakis in White Plains, Marlene's attorney, now formally opposing the executor designation. The letter was addressed to Holloway's office and CC'd to Hartwell, Bryce, and Calder in my name. It was a formal notice of intent to file a petition challenging the will's execution under New York Surrogates Court Procedure Act Section 1404, on grounds that the testator lacked sufficient capacity at the time of signing. I read it twice. Gregory Shawn had 17 years of general practice experience. His firm handled family law, residential real estate, and some light estate work. He was not a specialist. I printed the letter and added it to the file. The hearing was scheduled for 6 weeks out. Marlene called again 10 days before the hearing. I took the call from my office, which she did not know. I had put her on speaker and was looking out the window at the Midtown skyline while she spoke. "I want you to know," she said, "that this isn't personal. This is about what's right for Ruth's estate. Becca has been there. She's been managing the practical realities. We have documentation of her involvement. The attorney feels confident." "I'm sure he does," I said. "I also want to say, and I mean this genuinely, that I know you've worked hard. I know you've built something, and we're not trying to erase that. But being an executor requires a specific kind of involvement, a presence, and the reality is that you've been very absorbed in your career." "I agreed. "So we think a formal petition is the right path, just to let the court sort it through." "I think that's appropriate," I said. "The court is exactly the right place for this." Another small pause. She had expected again some resistance, some indication that I was rattled. "Well," she said, "all right." "All right," I said. I kept my hands flat on the desk. I looked at the window, then back at the letter from Gregory Shawn that was sitting open in front of me, and I said nothing further until she filled the silence herself with a goodbye. She thought she had won. She had 11 more days. Warren Holloway's office had by that point prepared the full estate accounting for submission to Surrogates Court, and the number at the top of the inventory, the gross value of Ruth Adeline Calloway's estate, was $1.4 million. Held in a combination of savings, an investment property in Bergen County that she had owned since 1981, a retirement savings account that had been carefully managed by a financial advisor named Theodore Ames of Ames Wealth Management in Hackensack for 22 years, and the college fund in Tab F. Marlene did not know the number. Her attorney had not yet formally requested the estate inventory, which was his first significant procedural error. He was operating on assumptions. In the law, assumptions are expensive. The surrogate's court hearing took place on a Thursday morning in April at the Manhattan Courthouse on Chambers Street. I arrived at 8:15. The hearing was at 9. I wore the charcoal suit I wore to contested hearings because it had the right weight to it, the kind of suit that reads as authority without announcing itself. Warren Holloway was already in the corridor, along with my paralegal, Dana Kim, who had been working with me for 3 years and who had spent the last 2 weeks indexing every document in the Callaway file with the kind of systematic precision that reminded me, every time I worked with her, why I had hired her. Gregory Sean arrived at 8:40 with Marlene, Becca, and Derek. They walked in as a group. Marlene was in a navy coat. Becca was carrying a folder. Derek looked like he would rather be somewhere else, which was honest of him. Marlene looked at me. Something moved across her face, a brief recalibration, because she had presumably been told that I was an attorney but had not, until this moment, fully processed what it meant to see me standing in a courthouse corridor with a paralegal and a file box, and the calm demeanor of someone who was on her own ground. She nodded at me. I nodded back. We went inside. The presiding judge was the Honorable Clarence Muir of the Surrogates Court, a man I had appeared before twice before on unrelated matters, and who had, in my professional experience, an extremely low tolerance for procedural sloppiness and an extremely high tolerance for thorough documentation. Which suited me precisely. Gregory Sean opened with the standard 1404 petition argument. Testator age, recent change of executor designation, the claim of diminished capacity at execution. He was competent. He was also working without the estate inventory, without the medical records, and without apparently any awareness of who was sitting at the respondent's table. Judge Muir looked at the respondent's table. "Ms. Voss," he said, "you're appearing as executor, and as counsel for the estate, Your Honor, in coordination with Mr. Holloway of Holloway and Slade, who holds primary file on the decedent's trust documents." Muir looked at Sean. "Mr. Sean, were you aware that opposing counsel is a specialist in trusts and estates?" Sean said. "I understood Ms. Voss was an attorney, yes." "Senior partner," I said, not loudly. "Just precisely. Hartwell, Bryce and Calder, trusts and estates, 11 years. Marlene's chin moved, a small motion. The kind of motion that means a sentence was started and stopped before it reached the mouth. Muir nodded and made a note. "Proceed." Warren Holloway presented the execution record first. Ruth Callaway, present in sound mind, 2 witnesses, attorney present, signatures obtained on a Tuesday afternoon in September, all in order. He presented the 11-year history of trust document amendments, showing a consistent pattern of intentional, incremental revision. Then I stood up. I presented Ruth's medical records first. Dr. Sandra Abubakar's chart notes going back 4 years, showing a patient with well-managed blood pressure, early macular degeneration, vision impairment, not cognitive, and no documented history of confusion, memory lapses, or behavior inconsistent with capacity. I presented the neurological screening from 14 months prior, a clean result across all major markers. I presented the specialist appointment records showing every referral Ruth had received in the preceding 2 years, none of which had been for any form of cognitive evaluation because none had been warranted. "That was the first document," I said. "I have 3 more." Sean objected on relevance. Muir overruled. I presented the health insurance coverage records, specifically the claims history, which showed no claims whatsoever for memory care, cognitive therapy, or specialist appointment in any neurological or psychiatric domain in the preceding 5 years. I presented this not as a standalone piece of evidence, but as a coordination document, cross-referencing the insurance policy against the medical record, against the execution date, the same coordination gap method that Howard Brennan had described to me years before in a different office in a different context, and which I had built a career on finding. "The petitioners are claiming diminished capacity at execution," I said. "The medical records, the insurance records, and the attending physician's documentation are unanimous. There is no evidentiary basis for the claim. Marlene said something to Becca in a low voice. I heard my name. I did not react. The third document was Tab F. I had debated whether to introduce it, because it was personal in a way that the medical records were not, and because I am careful about the line between evidence and emotional argument. But Warren Holloway had advised me that it was directly relevant to the question of the testator's intent and deliberateness, and he was right. I submitted it into the record and read the relevant section aloud. Ruth's own handwriting, her own words, explaining the college fund she had established in 1998 and why she was correcting its non-distribution now. The room was quiet for a moment after I finished. Muir looked at it. He looked at me. He looked at the petitioner's table. Mr. Sean, Muir said, do you wish to respond to the medical record submission? Sean asked for a brief recess. Muir granted 10 minutes. During the recess, I stood at the window on the far side of the courtroom and drank from the water bottle Dana had put in my bag that morning because she always put a water bottle in my bag on hearing days. Marcus had texted me at 8:52. How's the room? I had not answered yet. I watched Marlene and Sean in conversation. Sean was doing what attorneys do when they are recalibrating under pressure. He was speaking calmly and methodically, but his legal pad was turned to a fresh page, which meant he was starting over. Becca was staring at the Tab F document that she had apparently obtained a copy of. Her face had gone very still. Not crumpled, still. The kind of stillness that means a person is processing something that does not fit into any category they had prepared. Derek was looking at the ceiling. Muir returned. Sean withdrew 2 of the 3 capacity objections and revised the petition to a single, narrow claim, arguing not that Ruth lacked capacity, but that the change of executor designation had been made under undue influence. I stood up again. Your Honor, the petitioner has just shifted the grounds of their claim, mid-hearing from capacity, to undue influence. I'd note that this is the first mention of undue influence in any document submitted by the petitioner. No evidence of contact between myself and the testator in the 6-week period before execution has been submitted, because no such contact occurred. I live in Manhattan. The execution took place in Fort Lee, New Jersey, at the offices of Holloway and Slade, which I have never visited. Holloway himself is present and can confirm. Warren Holloway confirmed. Muir looked at the petitioner's table for a long moment. Mr. Sean, he said, undue influence requires evidence of access, opportunity, and the susceptibility of the testator. You've submitted evidence of none of these. The medical record submitted by the respondent directly undermines the susceptibility element. What is the evidentiary basis for this revised claim? Sean said. Your Honor, my clients believe. I didn't ask what your clients believe, Muir said. I asked for your evidentiary basis. A pause. We would request additional time to develop the record, Sean said. Muir did not grant it. What Muir did, after a 40-minute recess during which he reviewed the submitted record in full, was issue a bench ruling confirming the validity of the will and the executor designation. He cited the medical records, the insurance documentation, the 11-year trust history, and the signed attestations of Warren Holloway as the presiding attorney. He noted, for the record, that the petition had been filed without the estate inventory, a procedural gap he described, in measured judicial language, as a significant oversight given the scope of the claim. The ruling was confirmed in writing 3 days later. The estate value, $1.4 million, passed into administration under my authority as executor. The fourth document, which I had prepared but not introduced because it had not been necessary, was a letter I had drafted to the court at my own professional address, on Hartwell, Bryce, and Calder letterhead, summarizing my qualifications, my years of practice, and my relevant case history. I had brought it in case Sean went further than he did. He had not gone that far. I put the fourth document back in my bag and walked out of the courthouse into April sunlight. Dana was behind me. She said that went well. It did, I said. The Tab F thing, she started. I know, I said. She nodded. She did not push it. That was why we got along. I stood on the steps for a moment. The city moved around me the way it always does, without awareness of individual outcomes, without ceremony. I had 32 other active files. I had a client meeting at 2 o'clock. I had a board meeting for a pro bono legal services nonprofit I had joined 2 years earlier, scheduled for Thursday evening, at which I was going to present a proposal for expanding estate legal services to low-income elderly clients in the 5 boroughs. Marlene and her family came out of the courthouse behind me. She stopped when she saw me standing there. We looked at each other for a moment. She said, "I didn't know." "I know you didn't," I said. "Why didn't you?" She stopped, started again. "You could have just told us." I thought about how to answer this honestly. "You told me," I said carefully, "that I didn't have the temperament for serious things. That being quiet wasn't a skill set. I decided to let the record speak to that." She looked at me for a long time. Something moved behind her eyes that I recognized and did not name. Then she nodded once and walked to the car where Becca and Derek were waiting. I watched them go. The formal estate administration took 14 months to complete. Gregory Sean submitted a formal withdrawal of the petition within a week of Judge Muir's bench ruling. No appeal was filed. The college fund, $31,400 in principal, which had accrued interest over the years to a total value at distribution of $44,800, was distributed to me as a specific bequest named in the will, separate from the executor's fee I was entitled to under New York law. The investment property in Bergen County sold in month 8 of administration for $612,000. Theodore Ames, Ruth's financial advisor, coordinated the retirement savings account distribution. Every creditor claim was resolved within the standard administration window. The estate closed clean. Marlene did not contest anything further. She and I have spoken twice since the ruling, once at Ruth's memorial, which was held in the spring, and once when she called to ask a question about a document she had received from Holloway's office relating to her share of the residuary estate. The first conversation was brief and careful, the way conversations are between people who have been through something large together and are still finding the edges of what it changed. The second was professional. I answered her question. She thanked me, we hung up. I do not know what she tells people about what happened. That is not something I can control, and I made peace a long time ago with the things I cannot control. My mother and I talk every Sunday. She has never directly addressed what happened in the courtroom, but she asked me, one evening a few months after the administration closed, whether I was glad I had become an estate attorney specifically, whether the work felt like mine. "Yes," I said, "it always has." She was quiet for a moment, then she said, "Ruth knew, she always knew." I believed her. Marcus made partner the same year I did. We celebrated together at a restaurant on the Upper West Side with too many people and not enough seats, and at some point in the evening he stood up and gave a toast that mentioned, without naming names or specifics, that some people build their entire careers out of being underestimated. He looked at me when he said it. I raised my glass. My grandmother's handwritten letter, tab F, is framed. It hangs in my home office, not my work office. Work is for documentation. Home is for the things that matter in a different register. I read it sometimes, late in the evening when I am reviewing a file that involves a client who is trying to protect something for someone they love in a world that is not always arranged to help them do that. I read it, and I remember that Ruth kept receipts since 1979. That she had a ledger in a kitchen drawer. That she said, "Tell me what you learned, keep doing that." She had been keeping a different kind of record the whole time. Becca, to her credit, sent me a note 3 months after the hearing closed. It was handwritten, which surprised me. She said she had not known about the college fund. She said she was sorry. She said she hoped I believed her. I wrote back and told her I did, because I think I actually do. Derek has, as far as I know, continued to look at ceilings. I hired a new associate last spring, a woman named Fatima Osai, 28 years old, who had worked her way through law school on loans and a part-time job, and who came to me with a 3.69 GPA and a LSAT score of 161, and a cover letter that said, in the second paragraph, "I know what it means to need someone to treat your questions as legitimate. I intend to provide that to every client I serve." I called her myself after I read the cover letter. I offered her the position during the call. She starts in September, and if there's anything this experience taught me, it's this. 1. The quietest people in the room are often the ones building the most carefully. Patience is not passivity, it is precision applied over time. 2. Documentation does not lie. Institutions built on evidence hold, and the most powerful thing you can bring to any dispute is the record that other people assumed you were not keeping. 3. Who you are is not determined by who your family expected you to become. It is determined by what you build in the hours after they told you it was impossible. Was I wrong to spend 18 years building my expertise without telling my family what I was doing, and then to let them walk into a courtroom without warning? Tell me in the comments. If this story gave you strength, hit that like button. It means more than you know.